In a courtroom scene that shocked everyone present, the legal team defending former President Trump was ejected from a federal trial in what witnesses described as an explosive meltdown. It was unlike anything they had ever witnessed in a high-profile case, one that involved licensed attorneys losing control to such an extent that the judge had no choice but to physically remove them. The incident unfolded after the prosecution introduced an email that the defense had previously sworn under oath did not exist. What followed was a breakdown in professionalism, with the defense team accusing the judge of presiding over a kangaroo court. But this was more than just another contentious moment in the ongoing legal battle. It raised serious questions about the conduct of attorneys, their professional standing, and the future of their careers. The situation escalated to the point where federal marshals had to step in to escort the attorneys out of the courtroom, and the judge even threatened to refer them to the bar, signaling the gravity of the moment. The impact of the incident is hard to overstate. When marshals are physically removing attorneys from a courtroom and the judge is threatening professional discipline and criminal charges, it's clear that something unprecedented has occurred. Legal experts have expressed disbelief that seasoned attorneys trained in law school and sworn in after passing the bar could lose control in such a dramatic fashion. This is the kind of behavior that could ruin careers, leaving attorneys facing contempt charges, professional discipline, and even potential criminal liability. But what exactly caused this intense clash? To understand, we need to examine the events leading up to this moment and how tensions between the prosecution and defense had been building for days. The defense team had been presenting a strategy aimed at maintaining their credibility with the court, arguing that any problems with document retention were due to simple oversight, not malicious intent. They insisted that Trump acted on legal advice, framing the prosecution's efforts as politically motivated. For weeks, the defense had successfully cast doubt on parts of the government's timeline, even managing to get prosecution witnesses to acknowledge ambiguities in email chains and document handling. Their strategy was working well enough that some legal analysts even suggested that Trump might have a viable path to reasonable doubt on certain charges. But everything began to unravel when the prosecution introduced a new piece of evidence that would completely alter the defense's narrative. For days, the prosecution had been carefully building towards this crucial moment. They had laid out testimony regarding document retention policies, provided timelines through phone records, and built a case that suggested obstruction was intentional rather than a simple mistake. Then, on December 10th, the prosecution informed the judge that they needed to introduce a newly authenticated email. It was part of a larger document production that had not yet been shown to the jury. And when the prosecution revealed this new piece of evidence, the defense team immediately objected even before seeing it. It was a sign that things were about to explode in the courtroom. The atmosphere in the courtroom became charged as the prosecution handed copies of the email to the judge, the jury, and the defense table all at once. The email, dated August 2022, was a crucial piece of evidence that fell squarely within the period when Trump's legal team had been negotiating with the Justice Department regarding the return of classified materials. As soon as the lead defense attorney, identified in reports as Trump's primary trial counsel, read the email, the situation quickly escalated. He immediately stood up and demanded an urgent sidebar with the judge. The judge agreed, and the attorneys gathered at the bench, expecting a brief and private discussion out of the jury's earshot. But what followed was anything but a calm exchange. According to CNN's legal correspondent, who was close enough to the bench to catch parts of the conversation, the lead defense attorney quickly raised his voice, accusing the government of fabricating the email and demanding that the court declare a mistrial right on the spot. The judge, attempting to regain control of the situation, warned him to calm down. But instead of diffusing the tension, the attorney grew louder and more aggressive. He accused the prosecution of misconduct, alleging that the government was attempting to deceive the court. It wasn't long before the judge called a recess and had the jury removed from the courtroom, allowing the defense and prosecution to continue their discussion behind closed doors. Once the jury had been excused and the proceedings resumed on the record, the situation took another dramatic turn. The lead defense attorney, speaking directly into the courtroom microphone for the record, accused the prosecution of withholding exculpatory evidence, manufacturing documents, and engaging in what he claimed amounted to criminal fraud on the court. The judge pressed him for clarification, and that's when the attorney made a critical mistake. He insisted that his legal team had thoroughly reviewed all emails from that period and that the very email just introduced by the prosecution did not exist in any of the document productions they had received. According to the defense, this email had never been seen before, not until it was presented to them in court that morning. At this point, the prosecutor stood up and dropped a bombshell that would unravel the defense's position. She calmly informed the court that this email had in fact been produced to the defense back in September during the third document production. It had been clearly identified in the production index as item 4732. The prosecutor then handed the judge a copy of the defense's own pretrial motion, which referenced the very same email thread, but conveniently left out the most damaging part. The defense had even used portions of the email thread in their filings without ever mentioning the key detail now being highlighted in court. Reporters present in the courtroom described the tension as palpable, with Trump's attorney reportedly turning bright red in anger. Instead of acknowledging the mistake or stepping back to confer with his team, the attorney doubled down. He accused the prosecutor of lying, insisting that the email presented in their files had been altered after production. The judge, now visibly losing patience, asked if the attorney was formally accusing the prosecution of fabricating federal evidence. The attorney responded, "Yes, absolutely, that's exactly what I'm alleging." The situation had reached a boiling point and things were about to get much worse. The defense attorney's outburst was escalating beyond anything the judge had anticipated. As the courtroom buzzed with tension, the second chair attorney, sensing the situation was spiraling out of control, tried to intervene. He attempted to pull his lead counsel back to the table, but the lead attorney shook him off and continued to shout, doubling down on his accusations. He claimed that the entire prosecution team should be investigated for misconduct and went so far as to compare the situation to the infamous Watergate scandal. In an increasingly chaotic scene, he even went as far as to accuse the judge herself of complicity if she allowed the allegedly fraudulent evidence to be presented to the jury. The judge now, clearly exasperated, had heard enough. In a voice that was described as icy but controlled, she told the defense attorney that he was now in contempt of court. She ordered him to sit down immediately, warning that if he didn't comply, he would be removed from the courtroom. But the attorney refused to back down. He defiantly declared that he would not be silenced, insisting that someone needed to expose the truth of what was happening in the courtroom and that he was willing to go to jail to protect his client's constitutional rights. At that moment, the judge made the call. She looked directly at the federal marshals and issued a single firm command, "Remove him." Without hesitation, two marshals approached the defense table and moved toward the lead attorney. But the chaos didn't end there. The second chair attorney, perhaps desperate to protect his colleague, stood up and began shouting that the removal was a violation of Trump's Sixth Amendment right to counsel. He accused the judge of proving that the system was rigged against them. The judge, unyielding, raised her hand and pointed directly at him. "Him too," she ordered. Both attorneys were escorted out of the courtroom, while one of them continued shouting that this was a kangaroo court and that the truth would come out in the end. As the marshals led the attorneys out, the courtroom remained in stunned silence. A junior attorney from the defense team was left at the defense table, frozen in shock, as the full weight of what had just happened began to sink in. This was not just a momentary lapse in judgment, it was a dramatic and highly public breakdown of professional conduct that would have lasting consequences. For the defense team, this was a turning point. They had just lost control of their own case in front of the jury and the public, and the damage to their credibility was irreversible. This was far from the first time that attorneys representing Trump had found themselves facing professional consequences. Take Rudy Giuliani, for example, who was once hailed as America's mayor, but became a disbarred lawyer after his false claims about election fraud on Trump's behalf led to legal and financial ruin. His decades-long career ended in disgrace with lost licenses and a significant defamation judgment. Then there was Sidney Powell, whose baseless allegations about voting machines led to lawsuits, criminal charges, and her fall from grace as a former respected federal prosecutor. She became a symbol of conspiracy theories and unreliable claims, and now, with these latest events in the courtroom, it seemed that Trump's current defense team might be on a similar path. It's hard to ignore the striking pattern that seems to follow Trump's defense attorneys. Time and time again, those who engage in questionable or unethical behavior while representing him seem to face severe professional consequences. From Giuliani to Powell, and now potentially the current legal team, the pattern is undeniable. Lawyers who thought they could stretch the limits of acceptable conduct, make outrageous claims, and face no repercussions are discovering just how quickly their careers can unravel. It's clear that bending the rules to defend Trump comes at a steep price. The immediate trigger for the ejection of the defense attorneys was their blatant, demonstrably false claim to the court that the email the prosecution had introduced did not exist in any of the document productions they had received. This was a claim that they had made under oath, and when confronted with proof to the contrary, instead of retracting their statement, they dug in their heels and accused the prosecution of fabricating evidence. Legal ethics experts agree that attorneys have a professional duty to be candid with the court. They cannot knowingly make false statements to a judge, and if they do, there is no room for negotiation or excuses. When Trump's lead attorney claimed that the email had never been seen before, he made a factual representation to the court. The prosecutor swiftly disproved this statement by presenting the defense's own production records, which clearly showed that the email had been provided back in September. At that moment, the defense attorney had a choice. He could have acknowledged the mistake, apologized, and moved forward. Instead, he chose to double down on his accusation, alleging that the email had been altered after production. He further escalated the situation by accusing the prosecution of criminal misconduct, a claim that requires concrete evidence, not just deflection in the face of being proven wrong. The judge gave him multiple chances to correct course. When the judge directly asked if he was formally accusing the prosecution of manufacturing federal evidence, he did not walk it back. He maintained his stance, effectively painting himself into a corner. That's when the judge's decision was made. Legal analysts have pointed out that this was the moment when the attorney crossed a line that no competent lawyer should ever cross. You do not accuse prosecutors of criminal behavior without extraordinary evidence, especially when the record clearly shows that your own statement was false. The judge, having already given the attorney several opportunities to correct his behavior, had no choice but to order his removal from the courtroom. And once the second chair attorney stepped into the chaos, the situation became even more untenable. By joining the shouting, he sealed his fate as well. The moment the judge orders someone removed from the courtroom, anyone who exacerbates the situation is now subject to removal too. This, in turn, left Trump's case in a precarious position. With his lead attorneys gone, the remaining junior attorney, who was clearly unprepared for such a critical role, was left to handle the remainder of the trial. Now, Trump's defense strategy had completely collapsed in the most public and damaging way imaginable. The jury had just witnessed his attorneys being ejected from court for making false statements and creating an uproar. That visual alone sent a powerful message. If Trump's own lawyers couldn't handle the evidence without losing their composure, what did that say about the strength of their case? To the jury, it likely seemed like a sign of desperation, a clear indication that the defense had nothing substantial to offer. In the eyes of the jurors, this outburst wasn't just a bad legal strategy. It painted the defense as weak and unprepared, making it harder for Trump's legal team to recover. The fallout from this incident isn't limited to the immediate impact on the trial itself. It also raises critical questions about how Trump will move forward with his defense. The remaining attorney, left to manage the trial without the experienced leadership of the ejected attorneys, now faces an uphill battle. This attorney must navigate the complexity of the case, handle cross-examinations, and develop legal arguments, all without the preparation and strategy that the previous team had carefully constructed over months. A case of this magnitude, with its high stakes and intricate details, is nearly impossible to manage without a full and experienced legal team. Trump now finds himself in an extraordinary bind, but the consequences of the meltdown extend far beyond Trump's immediate legal situation. The behavior exhibited by the defense attorneys has already shaken the legal community and drawn widespread condemnation. Legal ethics experts have made it clear that the conduct displayed in the courtroom on that day is career-ending. These attorneys will almost certainly face bar complaints, and they could be held in contempt of court beyond the immediate removal, with sanctions potentially including fines or suspension of their licenses. In the words of Andrew Weissman, former FBI general counsel, This type of misconduct could lead to criminal contempt charges as well. Making false statements, accusing the prosecution of crimes without evidence, and refusing a direct court order to stop disrupting the proceedings is a violation of the most basic principles of legal conduct. The ramifications of the meltdown were further complicated when Trump posted on Truth Social during the lunch recess, attacking the judge personally and praising his attorneys for standing up to what he called a corrupt system. Legal experts immediately pointed out that this was a misguided response, as Trump's public criticism of the judge, while his attorneys had just been ejected for similar misconduct, could be seen as an attempt to manufacture errors or mistrials. If this turns out to be a coordinated strategy, it could only worsen the situation. Looking ahead, the immediate impact on Trump's trial is severe. He now faces the rest of the case with only a junior attorney leading his defense, a position that is virtually untenable given the complexities of the case and the damage to the defense's credibility. The jury has already seen the attorneys behave in a way that suggests a lack of professionalism, and the psychological toll this will have on the jurors cannot be overstated. Legal analysts have pointed out that juries often make negative inferences when the defense team behaves in such a way, viewing it as a sign of guilt or desperation. Moreover, this incident has wider implications for Trump's other legal battles. Several law firms that had previously considered representing him in other matters have now refused, citing concerns over the ethical implications of taking on his cases. With each new controversy, the pool of competent attorneys willing to represent him continues to shrink. The broader legal community is watching closely, and the message is clear. Attorneys who abandon professional ethics for a client's defense will face serious consequences. In the long term, this episode could set a dangerous precedent for the legal system. If attorneys can lie to judges, defy direct orders, and make baseless accusations without facing meaningful consequences, it undermines the integrity of the entire system. The fallout from this courtroom meltdown sends a message to all attorneys. No matter how high profile the case, no matter how powerful the client, the rules of professional conduct must always be upheld. For Trump, the legal battle has just become even more challenging. The ejected attorneys will face bar complaints, potential criminal contempt charges, and the professional fallout from their actions. Trump now faces a weakened defense team and an uphill struggle in court. The jury has already witnessed the complete collapse of his defense strategy, and the path forward is uncertain. The consequences of this breakdown are far-reaching, not just for Trump and his legal team, but for the integrity of the legal profession as a whole.